Hello and welcome to St. Peter's Law Academy. In this brief yet informative video, I am going to tell you something about reservation in government jobs, especially in light of the recent judgment of the Supreme Court in Judgement Of S.C case. Well, reservation in government jobs has remained a burning issue in our country because as a resource, government jobs are limited and claims or demands to it are of unlimited nature. Therefore, social conflicts are bound to arise, and social conflicts have been there. So, in order to settle this conflict like situation, a reservation in government jobs were first extended to the members of the scheduled castes and scheduled tribes, and later on to the OBC. Now, regarding the constitutional provisions regarding reservation in government jobs, we will have to cast a look at Article 16 of the Indian Constitution. In fact, Article 16 forms part of the Equality Code, which is contained in the Constitution from Article 14 till Article 18. Article 14, in a manner of speaking, contains the basic principles as to equality. One is equality before law and the other is equal protection of laws. They are not different from one another as such. Equality before law means everyone is equal in the eyes of the laws, whereas equal protection of laws simply means that despite equality of law, despite the promise of equality of law, state is well empowered to do a reasonable classification among persons so as to single out the weaker sections of society, the disadvantaged groups of society, in order to extend to them extraordinary benefits so as to bring them up to the level of the developed classes of society. And Article 15 expands the theme of Article 14, and it says that states shall not discriminate on the basis of religion, caste, race, sex, place of birth, etc. And furthermore, Article 16 runs on the same line, and it says that there shall be equality of opportunity in public employment. It means no discrimination in government jobs on the basis of religion, race, caste, sex, place of birth, place of residence, etc. But at the same time, in the spirit of equal protection of laws, Article 16 Clause 4 says or enables the state, means government at the center and the state both. Article 16 Clause 4 enables the state to provide for reservation in government jobs in favor of backward class of citizens. So first, the state will have to identify who all are the backward classes of citizens. And in order to accomplish this exercise, there is a mechanism in our constitution. I will tell you about that in some other video. But thanks to the constitutional mechanism whereby the backward class of citizens can be identified, the members of the scheduled castes and scheduled tribes, they have been always considered backward class of citizens. And even prior to the coming into effect of the constitution, the members of the scheduled castes and scheduled tribes were given reservation in government jobs. Some lump sum amount of reservation was given to them. Later on, after the commencement of the constitution, this reservation in favor of the scheduled castes and scheduled tribes was given to them in proportion to their population. So presently, scheduled castes have 15% reservation in proportion to the percentage of population that they have in India. And the scheduled tribes have almost 8%, 7.5% reservation to be precise, in government jobs. And in pursuance of the recommendation of the Mandal Commission in 1979, the members of the OBC, other backward caste, were also said to be forming the overall category of backward class of citizens. OBC is the name given by the second backward class commission itself. Mandal Commission had said that caste is a very important indicator so far as the identification of backward class of citizens is concerned. So the members or the castes which are not forming part of the SC or ST and who are yet backward were given the name of the other backward caste, OBC. And as per the observation of the Mandal Commission, the OBC constituted more than 50% of India's population. And it was the recommendation of the Mandal Commission in 1979 that OBC should be given reservation to the tune of 27% in government jobs. Now, this recommendation was liked to or appreciated by the successive governments, but nothing concrete was ever done till 1990. In fact, the Congress-led government at the center was non-committal about whether to give reservation to the OBC or not, because the upper caste people formed the greatest vote share of the Congress party at that time. And that's why, fearing a backlash from the general category voters, the Congress party never chose to go ahead with implementing the recommendation of the Mandal Commission so as to give reservation to OBC in government jobs. But in 1989's Lok Sabha election, mind you, in 1989, the general election was taking place in India, and the Congress party was still the ruling party at that time, and it had a very commanding majority in the Lok Sabha. But in 1989's election, the Congress party lost, though it emerged as the single largest party, but it was not in a comfortable position to form the government at the center because it didn't obtain the magic figure of 273, which constitute the majority mark in order to be able to form government at the center. And at the second rung was the Janata Dal, led by Mr. Vishwanath Pratap Singh, Chaudhary Devi Lal, Mulayam Singh Yadav, Lalu Yadav, etc. So Janata Dal was at the second position, and Bharatiya Janata Party was at the third position. Thanks to the support extended to the Janata Dal by the Bharatiya Janata Party, a coalition, a government at the center was formed. The BJP didn't take part or didn't form part of the government. So it was a government, formed on the outside support of the Bharatiya Janata Party. So this Janata Dal government led by Sri Vishwanath Pratap Singh, he had become the Prime Minister in December 1990. And true to its promise, the Janata Dal government, made its intention clear as to whether they are going to give reservation to the OBC or not. Accordingly, on 13th of August 1990, a government through an official memorandum, reservation to the OBC was announced, and this government order of the union government created a wildfire in India. The students from general category, the students of general category, they took to the streets. They indulged in destruction to public property. All sorts of violence broke out. Arson, self-immolation also was resorted to in order to show protest to the policy of the government, in which the government had, notified reservation for the OBC to the tune of 27%. But the government at that time, the Prime Minister being Mr. Vishwanath Pratap Singh, never buckled under the pressure of these protests and demonstrations. But political turn of events transpired in such a manner that this government had to resign halfway through, and a breakaway faction of the Janata Dal formed the government at the center thanks to the outside support of the Congress party. And this breakaway faction of the Janata Dal, led by Mr. Chandrasekhar, formed the government. Mr. Chandrasekhar became the Prime Minister. But for one reason or the other, Congress party also withdrew support from this government, as a result of which the Chandrasekhar government had also to resign. So in such an uncertain scenario, the President of India was constrained to dissolve the Lok Sabha, and fresh general elections were announced, midterm elections were announced. And during the election campaign, the Congress leader, the former Prime Minister Mr. Rajiv Gandhi, was assassinated in Sri Parambadur in May 1991. And, a sort of sympathy wave was, created in favor of the Congress party. And the election results were largely in favor of the Congress party in 1991. And the Congress party formed the government again at the center. And no person from the Gandhi family was ready to become the Prime Minister. So the former Chief Minister of Andhra Pradesh state, a senior leader of the Congress party, Mr. P.V. Narasimha Rao, became the Prime Minister of India. And Mr. P.V. Narasimha Rao's government observed that the general category students are not still, pacified. They are still showing their protest and demonstration in order to do away with the reservation to the OBC, which was pronounced by the erstwhile BP Singh government. So in order to find a solution to this problem, the P.V. Narasimha Rao government issued an order by which general category students were also given reservation in government jobs on the basis of economic backwardness. And this reservation was in the amount of 10%. 10%. So this way, reservation in the amount of 15% was in favor of scheduled caste from previous times. For scheduled tribes it was 7.5%. For OBC it was 27%, and now came the order of the union government in which general category on the basis of economic backwardness were given reservation to the tune of 10%. But mind you, this government order was impugned before the Supreme Court in Indira Sahni case, in the landmark Indira Sahni versus Union of India case. And in this case, a constitution bench of the Supreme Court pronounced a judgment in 1992 and set aside the government's order in which 10% reservation in government jobs was extended to general category students. The logic or the reason that was proffered by the Supreme Court in its judgment was that, see, Article 16 clause 4 only guarantees or enables a reservation to be made in favor of backward class of citizens. What is the sense of backwardness here? What are the indicia of backwardness here? It is not clear from the plain reading of Article 16. And applying the well-born rule of interpretation, which is expressed in Latin in the form of judgem generis, the Supreme Court said that if we are not able to gather the total meaning of a particular provision, then we may cast a look at the neighborhood provision, applying that interpretation rule of judgem generis. So the Supreme Court applied or gave its attention to Article 15 of the Constitution, where backward word has been used with two indicators, with two qualifiers: socially backward or educationally backward. So the Supreme Court said in its judgment in Indira Sahni case that the constitution makers, when they use the word backward in Article 16, they might have had the same sense as is there in Article 15 of the Constitution. And if we cast a look at Article 15 of the Constitution, there the backwardness, the term backwardness is qualified by social and educational backwardness, not economic backwardness. That's why it is constitutionally not justifiable nor permissible to give reservation to economically backward classes of people as such, because it is not in accord with the scheme of the Constitution, to say the least. So a judgment was thus pronounced, and in which the general categories students' reservation was outlawed. And in this judgment itself, applying the rule of harmonious construction of the Constitution, the Supreme Court, by reading Article 335, also further said that we will have to put a ceiling on the quantum of reservation so as to maintain efficiency in administration, as is expected of in Article 335 of the Indian Constitution. So this, by way of a harmonious construction of the provisions of the Constitution, the Supreme Court pronounced an outer limit of sorts. The limit to what extent can a state give reservation, and the limit as it was pronounced was 50%. So no more than 50% reservation will be given. This became the settled law thanks to the judgment of the Supreme Court in Indira Sahni case in 1992. This was the hurdle which was to be crossed, and so as to give reservation to general category students in future. When the present generation of these general category students started showing their protest in recent times, the government of India was constrained to propose a bill, Constitution 124th Amendment Bill, in the Houses of Parliament, and finally it got enacted as a Constitution 103rd Amendment Act 2019. And this Constitution 103rd Amendment Act 2019 has added Clause 6 in Article 15 and Clause 6 in Article 16 as well. Now this Clause 6 in Article 15 tries to process the impediment that was pronounced in the Indira Sahni judgment. Mind you, in the Indira Sahni judgment, the Supreme Court had said that so far as the backwardness, so far as the interpretation of backwardness in Article 15 and 16 is concerned, that backwardness has to be limited to the idea of social and educational backwardness only. And this Constitution amendment, namely 103rd Amendment, has done a change in the whole scheme of Article 15 by adding Clause 6, which says that nothing in this article shall prevent the state from making special provisions in favor of economically backward classes of citizens who are not counted in the purview, under the purview of Article 15 Clause 4 or Article 15 Clause 5. Means other than SC, ST and OBC, if there are any backward classes of citizens on the basis of economic backwardness, then in their favor also some special provisions can be made by the state. And furthermore, Clause 6 has been added in Article 16, which says that state can give reservation to economically weaker sections of society, and that may cross the limit of 60%. So these general category students can be given reservation to the tune of 10% in government jobs. This Constitution amendment was impugned for judicial review in Janhit Abhiyan versus Union of India case, and in this case a 5 judges Constitution bench has now given its judgment in November 2022, and the majority of the judges have upheld the constitutional validity of the Constitution 103rd Amendment Act, and it has pronounced that this Constitution 103rd Amendment Act and the changes brought in by it are not violative of the basic structure of the Constitution. Writing the judgment for the majority, Justice Dinesh Maheshwari has written in his judgment that the reservation in government jobs is an instrument of affirmative action. So all the disadvantaged groups, whether they are socially disadvantaged or educationally disadvantaged or economically disadvantaged, they all have to be brought within the purview of reservation. They can be brought within the purview of reservation because the purpose of the reservation or affirmative action is to ensure an all-inclusive march towards the goal of an egalitarian society. So there is nothing wrong in reservation in government jobs being structured singularly on the basis of economic backwardness, because those who are socially and educationally backwards have been given reservation in government jobs already. If something is being done to provide reservation to those who are not part of the SC, ST or OBC category on the basis of economic backwardness, nothing can be said to be wrong about it. And because this is the fulfillment of the requirement of non-discrimination, which is the signature tune in Article 15 and 16. And in order to give compensatory, in order to ensure compensatory discrimination in the favor of economically backward classes, this reservation was very much called for, and in fact it was very appropriate. It is not violative of the equality code as such, nor is it violative of the basic structure of the Constitution. So general category students now have reservation in government jobs.